Good afternoon. My name is Anupam Chander. I want to begin by thanking our host, the University of Hong Kong, and in particular, of course, Hao Chen Sun for organizing this spectacular conference. I'm delighted to see at the second to last panel of 2 days, the room is full. So the speakers are worth your attention and worth your time here. So I'm delighted that you're here. I also want to thank Grace for being such an incredibly wonderful host as well for everything. All right, so Grace is making everything work literally while I'm speaking. We have a fantastic panel. I will not spend any time on extensive introductions following the example of the last two moderators. Instead, I'm going to just turn it over to Sylvia Liu, who is a faculty fellow and visiting assistant professor at the University of Michigan, who will talk about regulating algorithmic harms.
So first of all, it's such an honor to be here, and I'd like to thank Hao Chen and for the University of Hong Kong for this opportunity to speak here. The presentation I'm about to give is mainly grounded in a working paper, reflecting my recent research, but also echoes the arguments and factual claims made by many other distinguished presenters about how algorithmic harms increasingly affect us for a range of social, commercial, and legal reasons, and how this challenges the legal frameworks governing AI development as a dominant technology. And in my talk, I'll often use AI as a shorthand to refer to the sort of like the OECD-defined machine-based systems implemented in the private sectors. But occasionally, this term might encompass a wider scope. And I'll also use the term privacy to discuss the field of data protection and privacy in general. I think this is not okay. So as many speakers has pointed out yesterday, we are living in an area increasingly dominated by a multitude of AI applications. I would just like to share recent estimates of the historical and projected growth of AI applications based on data from just last month. So today, AI services are widely used with more than 70% of people using them, although only a third of us are aware of its existence. It has contributed to a global AI market valued at more than $150 billion, and is expected to grow 20-fold soon. The private sector is crucial in AI development and applications, with half of companies using AI to innovate their services and products, and the number will continue to grow. By 2026, it's predicted that 80% of enterprises will have adopted generated AI models. So how does the expansive growth of AI applications impact our lives? As many of us here are aware, AI systems increasingly influence how we live. These technologies are integral to our smartphones, websites, social media algorithms, and even the increasing sensors scattered throughout our cities. However, while AI provides valuable services across a growing range of industries, it's not without its concerns. In fact, AI often leads to what many scholars, myself included, refer to as algorithmic harms. Although in many contexts, we do not see a very clear definition of what does it mean by algorithmic harms, many of those discussions refer to these as civil rights concerns that cause damage to users and the broader public. So to give you some examples, consider a few applications adopted by companies. Facial recognitions, as many of our presenters has pointed out, are designed to do a lot of great things, but like enhancing criminal identification, accuracy, or just simply identity verification. But it turns out that these systems can also be used to, or has been used to surveil people's behaviors, process our sensitive information without our consent, and even falsely identify innocent customers as shoplifters. These applications raise serious questions about the issue of data protection and fairness, accuracy in such systems. And there's more. Social media algorithms like recommendation algorithms are commonly deployed to boost social interaction and also user engagement. And in practice, they often extract individual behavior data, send us personalized content based on consumer insights, and maximize users' unhealthy reliance on their service. So users are actually subjected to algorithms that constantly send us potentially addictive content, incentive us to make more impulsive actions and increase our unhealthy dependence on these platforms. So some social media platforms, for instance, has already been sued for operating social media algorithms in a way that harmfully psychologically entrap young users, causing them in a higher proportion of suicide, self-harm, and mental illness. This outcome highlights the potential harms to autonomy, health, and safety arising from AI practices. So with the rise of ChatGPT, we can also see how its chatbot has been alleged to spread false and unhealthy information to over 100 million users within a year of its official launch. It was found to offer user biased suggestions and misleading contents that direct them in a wrong direction, among other investigations triggered by their misuse of medical and children's information. But what have been revealed in these reported cases are just the tip of the iceberg regarding algorithmic harms to our civil rights and to our society. Many of these problems have not been reported or revealed because many algorithmic harms can be intangible and invisible in nature. They are not like physical injuries that can be easily detected. Algorithmic harms often involve erosion of civil interests that I have just mentioned, like privacy, autonomy, equality, and health. So their effects are often indiscernible, not immediate, and even protected by trade secret law protection. For example, when we are subject to a surveillance of facial recognition AI, we may not immediately perceive any sort of inconvenience or danger from the non-consensual collection of our biometric data. And even if our privacy interests have been compromised, we may not be aware of the harm until identity theft occurs. These intangible harms can appear small and easily be overlooked, which lead to the next trouble, the aggregation of lots of unaddressed harms. So many harmful algorithm practices that I just mentioned can repeatedly conducted by different entities or organizations, allowing smaller problems to accumulate into substantial harms. For instance, our personal data collected by a checking app might appear harmless when observed separately, but as lots of websites and apps can extract our activities, data brokers and companies can form a fine-grained picture of our personal lives. And when a host of harmful practices are performed by numerous actors, we receive plenty of harms that undermine our interest. Ultimately, the sum of problems can become a social issue. So here I wanted to point it out how algorithmic harms can be both an individual problem, but also a collective social harm. Today, with the widespread use of generative AI, thousands of applications contain these problems. And when AI can reach millions, if not billions of users, repeated harms can add up to become more significant problem, undermining the function of democratic systems as a social harm. And it's not just a presumption. I think we have witnessed increasing evidence showing how the impact of algorithmic harm transcends not just individual scope. They also affect groups and societal functions, as we see how social media algorithms contributed to social events like the United States Capitol attack on January 6, 2021. The cumulative effect of algorithms that shapes people's actions and in fact people's decisions has the potential to compromise civil rights interests and also affect public safety to a greater extent. So as we increase our reliance on applications, we are exposed to increasingly ubiquitous harms arising from them as users. But how should the law respond to this problem? In the regulatory space of AI, the American approach heavily relies on consumer privacy regulations to address algorithmic-related problems. The prevailing view among privacy law scholars is that the notice and consent systems fall short in addressing the challenges posed by information-driven applications that involve exchange of data between private entities. So my work sort of echoes their critiques, but here I want to add that the existing privacy regime in the United States that has a individual and tangible harm focus fails to consider the more collective social dimension of algorithmic harm, and there is a widespread belief among experts that significant changes are necessary. And unlike the US, the European Union deploys a more restrictive regulatory approach to govern algorithmic harms. The EU's draft AI Act categorized AI into prohibited, high risk, and low risk groups based on the potential threats to fundamental rights. This approach really adopts lots of risk regulation toolkits like impact assessments and transparency rules that could hopefully enhance accountability in these AI systems. But it's unclear how its categorization of high-risk AI and associated toolkits have captured algorithmic harms that could aggregate to become more serious concerns and compromisation of those fundamental rights. It's also unable to to entitle individuals to avoid exposure to various forms of those collective harms. So the oversight in these regulatory approaches allows them to compromise our important interests while eluding legal scrutiny. As we see more concrete evidence illustrating the inadequacy of these frameworks, their shortcoming presents a critical opportunity for AI regulators to go further. So the first conceptual lesson is we need to advance our incomplete normative understanding of algorithmic harms. We can start with the more comprehensive conceptualization of the harms at stake. To achieve this, my work presents a typology of algorithmic harms that could categorize them into 4 core interest harms, including privacy, autonomy, equality, and safety, and their attributable harms, which involve outer problems like the lack of algorithmic transparency and accountability mechanisms, and also to describe their major problems, subcategories, and their regions, as depicted in this graph. The idea of this typology is to delineate the scope of civil concerns, bringing the law into closer alignments with the actual activities and aims to regulate. The second lesson is based on the typology, but more doctrinal in nature. So the rise of algorithmic harms has challenged the current regulatory tools for governing applications. With a deeper understanding of the harms at stake, we can enhance proposed legal tools to mitigate them. Various proposals have been suggested to achieve this. So my work sort of suggests enhancing these risk regulation tools with more thoughtful harm consideration. So drawing on this typology, we might consider implementing impact assessments for regulatory review to address collective harms. But because impact assessment tend to have a collective focus, it cannot really consider the individual variation or differences. We might also consider improving automatic decision-making rights to give individuals rights to potentially opt out of or have more control over harmful algorithmic practices with significant harm concerns. And also we may want to, as Xiaowei has pointed out in the morning, strengthening transparency rules toward more social oversight. So the main idea here is to enhance each of them through more harm correction consideration so that we can legally operationalize our broader legal interests concerning those crucial problems. This legal agenda, I hope, could pave the way for more institutional reform with further implications for governance. By adjusting our legal structures, we can more effectively address the complexity and challenges presented by the ever-evolving landscape of AI and its impact on civil interests in our society. So I'm just to stop here and look forward to other panelists' presentation.
Thank you. As they would say in the US Congress, you yield a minute of your time to Anne Cheung, who will speak next. She is professor of law here at the University of Hong Kong. She will speak on scoring and profiling beyond the SCHUFA decision.
Thank you. When I graduated from this law school, which was back in Stone Age, my classmate vowed that she would never go back to school. She would never take any exams anymore because she didn't want to be scored. But in this age of AI, is this possible? Our health scores are being marked and recorded by us, by our doctors, and by insurance companies. Our performance is being scored by our students and by our employers. And our ultimate happiness is also scored by our potential lovers. Scholars have argued that we are living in a scoring society and in a metric society. Famous examples of scoring includes the COMPASS system in the United States about the reoffending rate being scored. And the other famous example is about the FICO score about creditworthiness. Creditworthiness has a very long history dating back to the 1800s. In the second half of the 20th century, that statistical analysis has been used to score individuals in the US. The FICO score is very important. It has extended beyond the realm of credit scoring and borrowing money because this also affects our happiness. That is, this news is about a lady who shared her FICO score and which increases her dating scores also. So, powered by AI, scoring invokes great hopes, but also stirs great fears at the same time. One important byproduct is the prevalent use of data-driven profiling. Our common concerns in facing all this prevalent scoring are largely two basic questions. The first is, can we challenge our score if it is wrong or unfair? The second is, should the score determine how we are going to live? Part of the answers have been addressed by a very recent decision delivered last month by the European Court of Justice, that is the SCHUFA case. SCHUFA is very much like the FICO score. SCHUFA is Germany's largest private credit agency, which rates people according to their creditworthiness with a numerical score. Today, we explore two particular questions. The first is, has the SCHUFA case addressed the two major concerns which we have mentioned adequately? The second is, what are the wider implications of scoring, profiling, and prediction after the SCHUFA case to us as legal subjects? Maybe we start with the very brief facts of what happened in the SCHUFA case. It was about a lady, Ms. OQ. She applied for a loan but was rejected by the bank because her SCHUFA score was too low. Frustrated, humiliated, she requested SCHUFA to erase the entry concerning her, and she also requested to grant her access to the corresponding data. But SCHUFA agrees only to disclose her score and the general principles, but refused to let her know the exact weighting or how the calculation was being done. SCHUFA defended that it was trade secret. And SCHUFA also said that they will fear that if the algorithm was being disclosed, people will engage in gaming behavior and change their behavior to score higher points. Plus, SCHUFA also argued that the final decision maker was the bank, and they were not the final decision maker. According to the website of SCHUFA, actually there are 7 steps for them to reach this particular score, and that includes calculating our online purchases and also our relocations frequency. In details, they also mentioned that even inquiries about our current accounts, inquiries about borrowing money can be calculated into the score. So the legal issue before the court is whether the establishment of a probability value constitutes automated individual decision-making under Article 22 of the GDPR, which we have discussed this morning. We take a look at Article 22 again. Paragraph 1 stipulates that data subject shall have the right not to be subject to a decision based solely on automated processing, which includes profiling and which produces legal effects or similarly significant effects on an individual. I have underlined the 3 elements which the court has said the applicant has to satisfy. This right is not absolute because paragraph 2 has outlined 3 particular exceptions. One is that if it is necessary for the performance of a contract. Second is that if it is authorized by the state, which the state has already implemented adequate measures to protect rights, liberties, and legitimate interest. The third is that if the individual has given explicit consent. If paragraph 2 applies, then paragraph 3 has specified this requirement that the individual has this right to obtain human intervention and also the right to contest. So the court held that scoring is indeed an automated processing decision in this particular case because the number was being produced automatically. And the court said it is not so much the use, but it is in establishing the probability value using personal data of Ms. OQ and in evaluating and predicting her future behavior that makes it fall within Article 22. Plus that the number was being drawn strongly by the bank. That is, the score has played a determinative role in the final decision, producing legal effects affecting Ms. OQ. The second point that the court has confirmed is that an individual indeed has this right to know. And this right to know means the right to receive meaningful information about the logic of the automated decision. Otherwise, the individual will lack adequate protection of her rights. And the second point is that the states must provide suitable safeguards and ensure fair and transparent processing of data to the individual. In other words, this is a firm right to have access to information. The significance of the SCHUFA case is that the court has affirmed Article 22 about this is a prohibition in principle that an individual has the right to object to be subject to this automated decision making. Second is that this is not an absolute right, but subject to various provisions that we have mentioned. And the third is that an individual has the right to human intervention and the right to challenge this particular decision. So what are the implications? Is it only confined to Europe? In Hong Kong, we also have credit rating agency that is TransUnion. On the website of TransUnion, that it has boasted that 5.5 million consumers in Hong Kong have been scored by them. So very likely that we have a score being held by TransUnion. And with the long-arm jurisdiction of GDPR that was different Europeans being working here, studying here, they're very likely that we need to bear in mind about the implications of SCHUFA. But is SCHUFA only confined to credit scoring? We take a closer look. Recital 71 of GDPR, it has also mentioned 9 different dimensions of our lives, if it is being processed by automated scoring, that it will be regulated. So the controversies beyond credit scoring in Europe include different cases, namely in Finland, that is already back in 2018, the National Non-Discrimination and Equality Tribunal had already ruled that assessing credit score alone to make a decision constitutes discrimination. In Netherlands, the recent controversies is about using scoring to detect fraudulent behavior on childcare benefit scheme. In France, it's also using scoring to detect potential fraud on having this family allowance, and also about using scoring to allocate undergraduate places for students. In all these cases, we need to ask whether automated profiling has a determining role before a decision has been taken. If so, then we need to take into careful account into Article 22. So back to this fundamental questions that we raised earlier. How to challenge our score if it is wrong, or should a score determine how we live? That has SCHUFA addressed this adequately. So I will argue that to a certain extent that these 2 legal rights have been addressed, but how does this affect us as individuals, legal subjects? That in arguing that we have the right to know, the right to contest, this is premised on our understanding on the conditions for decisions of legal treatment. It is premised on the assumption that we can contribute and to contest. And such presumptions are subtle premise for human rights. But what is the consequence? Can we say no? Can we refuse to enter this scoring matrix? Nowadays, it is almost impossible for us not to be incorporated into an organization or government surveillance network. Without this score, like the example in Germany, that one cannot borrow money, one cannot rent a home, one cannot get a credit card. We need this identity that is an identity constructor for us to survive. We need to be predicted and inferred. Our life will be influenced and even being dictated, but we need it. So Professor Hildebrandt asked a more fundamental question about our data, about our datified lives. That is, to what extent human experience is computable or incomputable? What is lost is the inevitable flattening of the high-dimensional reality into machine-readable factors. And in every case of translation, something is being lost. Once being datified, the complexity of high-dimensional reality will be reduced to simplistic factors that are machine-readable. So what happened to us as ourselves? How do we understand ourselves in this age of AI? We have both an online identity and an offline identity. And knowing that our lives will be scored, our future will be scored, we tend to engage in strategic behavior and to engage in gaming behavior that SCHUFA was worried about. But we need this to fashion ourselves and to work on ourselves as a special project. We're leaving digital traces around. We start tracking ourselves and we also start grooming ourselves. Do we acquire and communicate a network of self? And how do we understand and experience ourselves? So in the end, we have become willing victims and perpetrators in these ecosystems and in this matrix. And I end with this quote: not everything that can be counted counts, and not everything that counts can be counted. Thank you.
Thank you, Professor Cheung. Now she's yielded in 1 minute, 30 seconds to the next speaker, who is Professor Michael Veale, a professor at the University College London. Professor Veale will speak on querying generative models for personal data.
Thanks, sorry.
No worries.
F11 doesn't work as it used to. Great, let me just. Okay, hi everyone. So I want to talk about the topic of the day in general, generative models. So you've all heard a lot about that. Apologies. And it's linked with data protection in particular. And I'm very glad that David went before me in the previous panel because this builds on and connects to some of the work, especially the more complicated things he was talking about. So I can maybe skip some of those, but we'll see. Just a reminder, we'll be talking about personal data, and personal data has a specific definition in both European law, but also much broader than that in Convention 108, which are signatories from other continents beyond Europe as well, and many domestic laws. And it's broadly structured like this: any information related to an identified or identifiable natural person. When we look at European jurisprudence, that's a very wide definition. Relates to is by content, meaning, or effect, so very, very broad. And identifiability is a very low bar as well. If it's just reasonably likely to be identifiable, and that's been defined very broadly by the court. So we talked about a very big definition in personal data. And I want to talk about models in particular. We talk a lot about whether personal data could go into models. We've talked a bit about web scraping, and we talked about the legal basis of that input also yesterday with regulators having that discussion. But models themselves are also being heavily personalized, and there are a lot of business models around those. So you find, as a hypothetical motivation for this paper, companies selling models that are virtual friends, where you actually poured a lot of your personality and discussions into those software systems. Also personal assistants that are meant to understand your preferences so they can respond to things, book meetings, choose the right seat on the plane that you might like, or something like this. Things that deeply have been imbued with your personal data. And also copies of individuals for writing. So you find markets emerging for influencers who actually could code the way they write, or the way they look, or even the way they act into models that can then be reproduced and reproduce them. Models that sing in their voice or something like this. Now, let's take the counter idea. When we're talking about models themselves being personal data, if we say they're not personal data, then it should be fine legally to publish these to the world. It should be okay. There are not generally going to be very big security obligations, at least not that stem from data protection law, on these models, because they're out of scope of the law. And so we have to be comfortable publishing them. But if we're thinking about publishing a model that is a personal assistant that actually would have a lot of individual preferences in, that would probably seem like something that we wouldn't want to do. We would want that to be kept secure. And even more trivially, we can think of examples of badly trained models. So you can train a model that overfits personal data. This kind of model will itself replicate personal data. It's much more like compression. And so if you badly train a model, well, it's like moving a personal data set from one place to another, and you can have it regurgitate the personal data on the other side. It's not a very good model. But what that says is it can't be about the technical form of these systems that determines whether or not it's a data set or not. And we've seen that with jurisprudence, like in search engines, things that don't conventionally look like data sets, or don't have that existing shape of a data set that we might recognize, get caught under the personal data definition nonetheless. To go further and to connect to some of the technical literature here, there are three main logics that I identify about behind models as personal data themselves: memorization, reconstruction, and enrichment. I'll go through them one by one briefly. Memorization has also been talked about in the context of copyright a lot, so you'll be familiar with this is reproducing an image. But let's look at some text for a moment. With text, we're thinking about verbatim reproduction of the training data. There are clear risks here for reproducing phone numbers, social security numbers, or private messages, deleted personal posts that were online, or so on, let alone risks when these data sets, these models are trained using data that was much more private to begin with and not publicly available. The broad way these have been tested for is through memorization attacks done by researchers, where you effectively ask the model the first half of a sentence that's in the data set and see how often it completes it with something that was in the data set already, and then you can do statistics over those. Carlini et al., a paper that was published in 2022, but was sort of formally published in 2023, indicates that an open source version of GPT-3, that kind of level of model called GPT-J, produced by Elutha AI, memorizes a lower bound, at least 1% of its training data. Doesn't sound like a lot, but that's a lower bound, like at least that, and could be more depending on the sophistication of the attack. This is a very preliminary paper. So they can recover that kind of data from this paper here. find the reference if you squint at the bottom. Now, this is not the same as overfitting, which you might be aware of from machine learning, where machine learning systems don't generalize well, they just remember too well, and they remember the past, but they don't generalize the future. And the Carlini et al. Paper actually shows that memorization of this type is key for functionality. It's a different thing than overfitting. It's not the case these are badly trained models. This kind of memorization is functionally required for the model to work. And you can do things like remove duplication of the training data, and that reduces the problem, but it doesn't remove it at all. So, deduplication is very difficult if people are talking about the same piece of text or quotes or so on in different texts as well. So we find that that's the memorization structure. But it's not the only thing that's relevant for personal data. Copywriters sort of stuck with that definition and gone not too much further. But personal data is much wider. This is a bit of a strange thing. Sorry, I wanted to show, for example, if this was GPT-4 and I set a system prompt and I said, give a the structured bio of the person whose name I put into the system, because I'm a self-centered academic, I put myself down, and you get a fairly accurate bio, almost no errors there. I don't have a degree from Cambridge, but everything else is actually correct, roughly, from that. So you can effectively pull out structured data from this. And in fact, you can ask it to provide that data in JSON format that will be immediately ingestible by a computer system or a large database and so on. So you can have methods to retrieve data about people who either willingly are in the public eye or just because of their professional obligations have to be more visible than other people. And if you imagine this being trained on broad data and so on, this is going to be more key. We know from the case law of the CJU that facts and opinions are personal and potentially sensitive data, even if they're incorrect, so that expressive data can be personal data too. And broadly, we should be concerned because LLMs function as this kind of mass data linkage machine. They are connecting not just things from bios, but they might be connecting things you've written on Reddit or your blog or so on in one stream together. So it's actually crossing contexts that people like Helen Nissenbaum have been talking about for contextual integrity. Privacy is very important. What I write in my blog or in a Reddit post is not the same as what I give to someone to put as a bio for a conference. And yet these systems will connect these together with no regard for context and therefore create a significant privacy challenge. So, and we'll also go back in time, look at people like Anita Allen have written about extensively, looking at just how far back that you would go, dredging up things from the past, dredging back your school athletic achievements or maybe more salubrious achievements that you've done at that point in time. So that's reconstruction. You see it's going beyond copyright because we can have a discussion about the Warhol case in the Supreme Court or whatever, but that's really on the fringe. We're talking here about personal data clearly encompasses something that can do question and answers with text that has never been seen before, but is a factor and assertion. The last one is enrichment and inference. This is a bit of a broader category, but just going from the observation that most data and online technology immediately pivots towards attention and advertising, we can think of models as forms of data storage and querying per user, so building models of users and their behavior to understand how they specifically will react to things like text or images. And this creates questions of data portability and access and agency, particularly because if your smart home is trained for you in a certain way, what right do you have to take that model somewhere else? And indeed, we see that in a variety of laws already. If that is the way that the personal data is stored, and you say, I want to move the data from one place to another, and the company says, well, the data is only in the model. There's no actual data set, it's just the model that is this. Then you get to a point where you either have no access or you need to have access to the model. It's one or the other, because the data set no longer exists, because it is in the form of a model. You also have models of other people that are created potentially by your companies trying to work with business clients or game negotiations or so on, that clearly are personal data of many kind because it will be trained on those specific people and designed to replicate them in a way. So we're clearly seeing here that we will have forms of data and models that are more specific to individuals, I'd say, and those are clearly within scope of the law. Let's turn to legal implications now. This is actually building somewhat on a paper that I wrote in 2018 with colleagues Ruben Binns and Lillian Edwards, where we looked at data within models, including language models, and the legal implications of treating models as personal data, which was a more arcane topic then, and less sexy. And the text was slightly more difficult to undertake. But I've gone a bit beyond that here because things have changed a little bit. So, some implications. You need to establish a legal basis for processing. The definition of processing is really wide, includes alteration, use, consultation, or storage. So to use a model of this kind, if you argue this model could consist of personal data, at least some uses of this model may require a legal basis to use, and you'll have to establish it. If you argue this model can contain personal data, then you may need to get a basis for international transfer of this model as well. If you move it across borders, then it would be a pretty big loophole in the law if you can move anything you want across borders by just turning it into a model and on the other side unpacking it. That also really can't stand as a loophole. So if you see organizations doing this, there's going to have to be a point where this transfer would be coming into the law. And sensitive data as well is difficult because you need a heightened legal basis, typically consent. For transparency, this is very interesting. If you consider a model to be personal data, then you need to declare the purposes of use or processing rather in advance. And so that's actually quite interesting for algorithmic accountability. You also need to declare the sources of the data that went into that model. And that is an absolute obligation. There's no sort of, if you can, if you know them, you have to declare those sources if they're there. And you have to, and if you know the recipients, there is obligation if you don't know the source of the data, but if you have the training set, then you will know the source. And a recent CJU case implies that it's the same for recipients. So whoever you gave the model to, then you will have to declare that. Now, if you take a model like Meta's Llama 2, Meta make every user of that model sign a contract that provides their contact details. And so if you argue that this model is personal data, then individuals may have a right to a list of recipients of this model, which Meta hold by the way they operate their licensing system. And they sign it through Hugging Face or through their own platform. Data rights, you may have a right to object to processing. And if you have a successful objection and it overrides any other legitimate interest, you may then be able to qualify for a right to erasure. Right to erasure is a much harder thing to qualify to in European law. And that may contain some challenges around masking data, which could be taken like as search engines are or others. And security obligations, keeping these secure, which creates challenges maybe for open source models if you're moving them around broadly, because personal data should be kept appropriately secure. So lastly, let me just look at some of the legal routes for courts where they could go with this challenge. Firstly, they could say, actually, generative models are not personal data. But then we get the arbitrage questions we've had before, and we get security problems we would seem to have around models being released, which could contain very sensitive data. It confuses identifiability with functionality and form. So you would say, well, the data doesn't look like data to me, even though it smells like data and acts like data. So therefore, it's not data. That doesn't seem to be very a sensible move. And it would throw a lot of jurisprudence into uncertainty. You could also say that generative models are only personal data when queried with some kind of intent. That's very similar to what David was talking about in the last panel. So with search engines, it's considered personal data processing when people's names and potentially similar queries are processed. But for closed systems and APIs, you could do the same thing and say, well, we'll try and block queries of names, we'll try and stop anything that relates to an actual person being visible to the user, and then we will say we're not processing personal data because they can't query those people. They could try that. But if you've got systems that are the code is available, you don't have the option to put those kind of technical restrictions on the model in the same way. And the ones that you can put on are extremely easily circumvented when you have access to the model itself, as research shows. Just fine-tuning them removes a lot of the deeply embedded safety mechanisms in the model, as a recent paper by Key et al. Shows this year, which is on this page. You could say, oh, we'll have a risk-based approach to material scope. Poses certain risks to people, then we'll consider it personal data. If not, then we won't. The challenge is that it might work for low-dimensional models where you can understand the varied areas of use, but high-dimensional models, there are so many things that you can query and piece together and uses that it will be very hard to reason about the potential functionality of these models. In fact, no research group is currently able to reason about the full range of capabilities of a model without just experimenting into it. So it's not something that is easy to do a priori. And when they try to, essentially they found it impossible to sanitize the model itself. That's why models come with safety checkers or other kinds of classifiers attached to them, and models come with potential worries about misuse, because you can't tweak the weights to make bad things not happen or not be possible to happen from this model. And if you do, they can be undone because these weights are heavily attached. Lastly, we might think that models are personal data, but controllers have very limited responsibilities for them. So that would take the case from the GC and others case, where we'd say the responsibilities, powers, and capabilities doctrine that David described in the last session might apply, that, okay, the data protection applies, but it can't, not all parts of it can apply because the technology does not facilitate rights to access it within the model or erasure within the model. And so that can't be part of the deal because the capabilities are not there. But this constructs both a judicially-led sui generis regime, not really great, but also leaves these code-available open models with very little legal clarity, because you can't actually at this point decide who's got these capabilities or responsibilities when the code is just moving out there in the world and can be examined by anybody and has a security risk. We don't send search engines to each other, so that's never been a problem, but we do send models to each other. So in sum, as Marie Kondo said, famous cleanup artist, I'm so excited because I love mess. I have a great solution for you, but there are some problems.
Thank you very much, Professor Veale. And thank you to everyone for sticking to the time. And I turn to Xiaowei Yu, who is a postdoctoral fellow here at the University of Hong Kong, working with Chen and with me as well. And so I'm delighted to have the opportunity to listen to Xiaowei. Her talk is titled Privacy Policies and Shared Meaning Analysis.
I have a good news for all of you. I'm the last person in this session, so you will be dismissed very soon, okay? So today I will share a collaborative paper with Robin Carr about this privacy policies and shared meaning analysis. So when using privacy policies are everywhere. When using LinkedIn, you probably noticed that a statement in small font says, by clicking this button, you agree to various documents, including privacy policy. Similarly, when placing an order through PayPal, you must check a box that states, by using this form, you agree to the storage and handling of your data by this website in accordance with our privacy policy. And in most cases, you won't see any direct notices unless you are a EU resident. And most of the time, you will find them at the bottom of the website. So privacy policies are self-disclosure documents posted by websites, platforms, apps, and any other digital service providers. They generally inform users about the types of data they collect, the timing of data collection, and how their data is used. Privacy policy really facilitates transactions between digital services and users, user data. Companies can collect consumer data effectively through contractual relationships, while consumers can make informed choices about how their data is used. So currently in the United States, privacy policies are often treated as contracts. In 2019, Facebook faced a class action lawsuit related to unauthorized access and misuse of user data by third parties, including a Cambridge Analytica scandal. To resolve this issue, the court focused on the contractual language of privacy policies. In 2021, the FTC reached a settlement with Flow Health, which is the developer of a fertility tracking app. The FTC took action because Flow promised to keep users' health data private and only use it to provide app services, but instead, they disclosed the data to multiple third parties. And in 2022, the restatement of consumer contracts stated that privacy notice can create contractual obligations, which is the dominant jurisprudence in this area. However, privacy scholars are really concerned about the contractual model of privacy policies. There are at least 3 obstacles that hinder individuals from giving valid consent. So the first one is called the intelligibility obstacle. People do not read privacy policies. Even they read, they don't understand. And as well as we have use so many algorithms, it is impossible for users to grasp all terms of the privacy policies. And second obstacle is called decision-making. So we are not 100% rational person. So we all have systematic bias. So that means if we read and understand privacy policies, we can still not make rational decisions. We cannot make the best choice for ourselves. And third obstacle is called a symmetry obstacle. Companies have more knowledge and control over data practices, and consumers always at a vulnerable position. Due to the information and the power asymmetry, companies can even manipulate or force consumers to give consent. So due to these obstacles, individuals cannot grant valid consent to privacy policies. Privacy scholars widely agree that the contractual model is ineffective, worthless. Some people say it's unethical, it's unjustified. Therefore, very few of them wants to use a contract law to solve privacy policy issues. So here we have a wrestling situation. Courts and regulators primarily adopt a contractual interpretation of privacy policies, while scholars seriously doubt the validity of privacy policy. And how should we do now? And in this paper, we think that the shared meaning analysis can help us to address this issue. The shared meaning analysis is proposed by Robin Carr and Margaret Braden in their article, Pseudo-contract and Shared Meaning Analysis. In this article, they identify a phenomenon that is called paradigm sleep in the US contract law. So Carr and Braden observed that in the last several decades, the US courts unconsciously stretched the older terms and concepts to new situations for the coherence of common law doctrines. However, it results a qualitative change. The original meaning of basic concepts under contract law is distorted. Contracts are not contract anymore. Contracts law are not about mutual agreements. Contracts are just unilaterally proposed terms. Similarly, agreements are not real mutual understandings. It is only one-sided proposals. Therefore, courts conflate pseudo-contracts with real contracts. So to solve this problem, Carr and Braden propose a linguistic tool, which is called shared meaning analysis, to distinguish pseudo-contract from real contract. So they believe that the formation of a contract is in conversations. Therefore, the language that is used to form a contract must be consistent with 4 conversational maxims: quality, relation, manner, and quantity. So just like 2 people talk to each other, when they want to reach a common understanding, their talk must be sincere, relevant, clear, and appropriate to the purpose of their conversations. By having those conversational maxims, we can decide whether any standardized clauses is part of the mutual agreement between parties. So if they are consistent with those maxims, then they're contractual. If not, they're non-contractual. Okay. So shared meaning analysis is a linguistic tool to accurately access the terms of privacy policies. By extending these tools, we can solve a lot of problems in privacy policy issues. So we can use New York Times as an illustration to help us to understand how this tool can help us to solve the problem. So first, by looking at the interface, we can find out that 2 sentences in the red frame are vital to form a contract. And then we can translate those sentences into if-then statements to better understand the meaning of it. So first, when we see that, thank you for reading the Times, create your free account, log in to continue reading. So the if-then statement could be, if you want to read this article, you must create an account. And the interface shows us, if you want to create an account, users must enter their email addresses and click continue button. then we can translate the web design as if you want to read this article, then you must enter your email address in exchange. Okay. So second, we see another sentence says, by continuing, you agree to the terms of service and acknowledge our privacy policy. And then the if-then sentence statement could be, if you want to read this article, then you must agree to the terms of service and privacy policy. When users actively enter their email addresses and click the continue button, we could say that they accept the offer of the first statement. But the question is whether they accept the offer of the second statement. Shared meaning analysis will ask whether the second statement, especially the full text of privacy policy, is part of the transaction between reading articles and email addresses. To answer this question, we need to think about 4 conversational maxims. We must decide whether the text of privacy policy is fully communicated with consumers consistent with 4 maxims. And in this case, the interface of privacy policy is delivered in a hyperlinked way. By clicking the hyperlinked privacy policy, it will direct people to a lengthy and complicated document. We argue that it conflicts with the maxim of manner and quantity because it says too much and it's not in a clear way. Okay, so for this reason, we could argue that most of the text of privacy policy in this case is non-contractual. And if after illustration, let's revisit the privacy policy issue with contracts law. Okay, now we at least have 3 insights after the application. So first, we think that privacy policies can deliver both contractual and non-contractual terms. So let's turn back to the New York Times example. Collecting email addresses in New York Times privacy policy is a contractual term in this case. However, the unilateral modification clause, which empowered the New York Times to unilaterally amend privacy policy at any time, is a long contractual term because it violates at least 2 maxims. And second, we think that a contract will definitely play some role in the privacy policy issue, but we have to first have the right conception of contract. So currently, both the law and privacy scholars assume an unjustified conception of contract. So it's not contract law doesn't work, it's because we tolerate a wrong conception of contract for such a long time. So the contractual model can definitely work as long as courts can correctly identify the scope of mutual agreement by using shared meaning analysis. And last, we think that shared meaning analysis can incentivize companies to really communicate with consumers. Currently, privacy policies are primarily written for regulators and lawyers, not for consumers. So if companies want to establish contractual relationships with consumers, they need to work hard. They need to initiate a real communication with consumers, such as they could put more efforts to have a more interactive interface or to have a better visualized web design to let consumers understand what they're exchanging for. Okay, so that's all I want to share today. Thank you.
All right, Xiaowei wins here. She yielded the most time to the rest of the panel and to you. I will ask a question just to have you guys start thinking about your questions. And let me see whom I want to interrogate first. I'm going to ask Professor Veale, how would you create an LLM that was privacy protective?
I think that's very difficult. How to collect a database of the web that is privacy protective in that manner. Certainly, there are. If you were training a model and it didn't have personal data in it, because it wasn't based on text that was describing things, then I think that would be fairly privacy protective. You would probably be able to achieve that if you were trading fully on, say, academic papers in general. Yes, it would have facts about authors wrote certain papers, but I think that those would be broadly considered under scientific
So
exemptions
just to-
and so on.
But one of the examples you used was your own description, right? So you'd have to train it not to be able to tell about people.
I think, so there we have a question about whether there are some things that are in the public domain that should be fair game because they're fair game on the web, and some things that are not. The point I'm making about that is the linkage point. So when you ask about somebody, it draws together information from a variety of sources, bios, without distinction between whether the bios come from, a conference web page, or whether they came from a newspaper article published 30 years ago, or whether they came from a personal blog post, or whether they came from a post since deleted, or something like this. And the idea that, quite trivially, you can pull up bios of people is the first step. The question about where those go, depending on the level and extent of data created, I think is another. I'm not sure that it's really, I'm not sure the question about how you train a privacy preserving LLM is a very fruitful one to follow. Because if you're building a model of the environment, and the environment is a social environment which contains facts about people, then those facts about people nonetheless fall inside data protection law. But let's bear in mind, data protection law is not actually, the GDPR is not actually a privacy law. Data protection is a totally different area and a totally different fundamental right. And it supports privacy, but it supports a range of other rights. It supports information asymmetry in a digital age. And so reducing information asymmetry. And so I think to those ends, we could say that, yes, there are some things that wouldn't be, you could have a model that data protection law would apply to, and therefore gives people rights to negotiate in many areas of their life, whether it's discrimination or defamation or equality or privacy, and those rights help them negotiate and navigate that, and the structures and the design rights maybe help create a landscape where those are done by default. And we may say that privacy rights are not infringed at that point for public-facing data. But just because privacy isn't engaged doesn't mean data protection isn't engaged. So I think that's maybe whether you could, and so taking just the last thing I'll say on that is taking your question and sort of turning it into how would you make a data protection friendly model? Well, you're not data protection friendly by falling out of data protection. Data protection is there, to support other rights in the fundamental rights world. Anonymization, data protection is not a harm. You're not like, oh, my data protection is being harmed. Data protection is a facilitative regime that we do in support of things. So you can have privacy harms, but data protection harms are not really something we conceive of. And I think that's where we should probably go to work out, maybe with another law, what kind of rights and obligations are useful to have in relation to models that fall into scope of personal data that actually help agency and help people achieve other fundamental rights.
Great, thank you. Now, Angela.
I have a question, kind of comments for Xiaowei, and also one for Michael. So Xiaowei, if I understand correctly, you're trying to the share meaning point was trying to alleviate information symmetry between the users and the company. But in reality, this kind of cognitive bias is exactly what social media is built upon, right? I mean, that's how the attention economy was able to exploit consumers' ignorance in order to capture those data, in order to profit. So I don't know, to a really long time, a lot of privacy scholars have been advocating, similar proposals, trying to level the playing field. So if that's the case, then they can't really reap so much data from the users. So the whole, free price, goods will no longer be available. Like, I mean, in your New York Times example, if New York Times, follow what you propose, probably it would be more expensive for us to read New York Times. So wonder what you think about it. And then for Michael, let me stand in the shoes of an industry practitioner. If I'm a large AI firm looking at what you propose, my reaction will be, look, I mean, I'm not going to disclose my data sources. This is my trade secret. The entry barrier into those large foundation models, computing power, I need very good technicians and the data, right? I mean, this is my essential source into building the foundation model. If I disclose all these things, I'm losing my competitive edge. And whichever jurisdiction that proposed this kind of disclosure requirement is going to create, exit of these firms. So I wonder, in reality, how likely do you think, any jurisdiction will really adopt something that you propose? I mean, I understand where it's coming from, but in reality, it's really hard to push for that.
First, okay, thank you. So first of all, I have to say, the shared mini analyze is not a tool to solve a symmetry problem. So it's a way to get back to the real contract that is about mutual agreement. So contract law has a symmetry problem, but contract law cannot completely solve all the symmetry problems. So maybe competition law or consumer protection law and data protection law can solve more than contract law. So what we are doing here is, if a company still wants to establish contractual relationships, we motivate them to contract the real contractual one, not the pseudo contract one. Don't call the pseudo contractual relationship as the real contractual, like everyone reads it and everyone is binding by those unilaterally proposed terms. So that's what we are doing here. Thank you.
And thanks for the question, Angela. I think obviously there was a short presentation, so I couldn't go into detail. But the data source requirements, in my view, would only relate to the data that related to you. And so if you said, okay, this model is putting out a load of things about Angela Zhang, and you said, I'm going to ask it for the source of the data that relates to you. Well, that seems eminently reasonable. You're not asking for every source. In fact, that could be data that's publicly available. In what case, what's the trade secret? What's the valid trade secret here? Nothing, probably, because it's publicly available data. Very hard to argue, I would say. I mean, bear in mind, all these companies argue trade secrets that are going to be very difficult to actually substantiate in court a lot of the time, because the bar is higher for these open source tools, which are trained usually using publicly known methods. If it's a private data set having things about you, well, then why wouldn't you have the right to do that? And why would we let trade secrecy say that this AI company is holding a data set about Angela Zhang that they are using to train the model, but they are refusing to disclose because of a trade secret? That seems like a very proportionate thing. You're not asking for every data set about everything in the world. You're asking for the sources of this particular data that relates to you. And so I think that actually in practice, these requirements can be whittled down. And I also feel that we need to push very strongly out back against the expansion of trade secrets around what are very commonly able to be created computational tools. Because these tools are not made using magic source, like the colleague from Meta was saying earlier on, who was in a conference yesterday, putting these tools in public. One of the reasons the companies do this when they do that is because other people can build upon them. Other people can point out errors. Other people can build tools. That's been long the case in machine learning. And so I find it very difficult a lot of the time to identify trade secrets in these areas. Now, I'm certain there will be some in minor parts, but data sources, I'm not sure that that's going to be something that should be protected. And I'm not sure that a court, if you really push on the facts, would always come down that we protected. So a nuanced understanding of what that means would really help here.
Other questions? Yes.
Thanks very much. Yeah, it's a question for Michael, and your presentation is built very neatly on the one that David gave this morning. So thanks for sort of teeing that all up for us if it was planned. My question, I suppose, is actually the answer you were giving earlier about perhaps talking about some of the solutions and who might else need to be involved. So I suppose the mess you referred to is currently on the desk, particularly of the European Data Protection Board and the task force that they've set up. So I suppose, have you got any observations of probably the most helpful things the task force could do in any guidance they put out? And then secondly, is there any hope that the text of the AI Act, when we finally see that, obviously we know it's got these newly added elements related to foundational models and the role of the AI office, can that sort of be part of the solution in trying to work through this as well?
Great questions. I mean, I think it's also on the desk of the ICO, because the ICO's guidance on this area specifically cites the paper that I wrote previously.
Yeah, it's on the
model
ICO.
inversion.
Well, I don't work for the ICO.
No, I know you don't. I know you don't. But okay, but the site cites that paper saying models can be personal data. Watch out when you make a model; it could be personal data. Here's what you should check. And then generative models come along, and the regulator is stuck with that guidance. Very interesting. The French CNIL also have the same issue. I think the biggest challenge, right, is around open models. Because if you have these closed models, then you can go down the route that David was talking about, and you can pretend with search engines, you can have a sort of, we control it at the query level, and you've got a lot more governance at that point. As soon as we say models are moving around, we are saying data sets are moving around. Now, there's not, on one hand, that might not be so big a difference from these kind of, no one really grappled with common crawl and these gigantic web scale databases. But that's because text was never very easy to search. I think we're coming to mainly with email. When people started to email each other very heavily in the 90s, particularly for personal reasons and business reasons, of course, email goes back to the 70s, but it brought a lot of data into the scope of data protection law, and it brought a lot of text. When data protection law was created, it imagined census-style data banks, but the scope includes anything that's automatically processed, so text came in. And there's an assumption in data protection law that if it's on a computer, it's quite easy to grapple with, which has never really been unpicked fully. But interestingly, language models make text quite easy to grapple with. So I think my advice to EDPB and other organizations would be, if these companies claim to have some of the best technologies in the world to navigate, sort, identify, find text, locate it, and so on, well, they need to be using that same capability for compliance. Because you can't on one hand say, we're making the best text analysis, delivery, and so on system in the world, and yet say, oh, and we can't find you in our big data set because we'd have to go through loads of text by hand. You know, it's not actually coherent. So going back to them and saying, well, we can see you've got the capabilities because we've read your sales pitch is an interesting strategy, I think, to adopt.
Great, yes.
So this question's for Dr. Liu. So I was really intrigued by the types of privacy harms that you were discussing, and I'm curious what you think about sort of the issues related to standing in the United States and how this might pose potential issues for recovering in sort of a newly conceptualized harms model.
Thank you for the questions. Yeah, I think we in our shared file, we have articles on privacy harms written by Cheung and also Daniel Solo, which discuss the problem of standing regarding how those kind of privacy harms can be so intangible, so that courts struggle to really recognize that there are cognizable harms, so that victims normally cannot get legal remedies they deserve. When I think about the issue, these kind of issues in algorithmic context, I assume that this kind of algorithmic harms, when currently in the US regulatory context, when we mainly relies on privacy-related sectoral regulations to address these questions, it would suffer the same questions faced by what we have in just purely privacy harms context. But when I think what's different between algorithmic harms and privacy harms is that I think algorithmic harms involve a lot of more varied and different broader issues, including from autonomy. Autonomy might be covered by privacy scope, but it also concerns lots of equality, health, safety, security-related concerns. And I think in many cases, a certain algorithmic practice can trigger lots of different types of harms. I think this is typical in what we have seen in some certain facial recognition related AI applications, and it's difficult to the problem of algorithmic harms. I think currently the major problem and major difference between privacy harms and algorithmic harm is that we still do not have a very comprehensive horizontal regulations that these new types of harms can be able to be legally recognized under like a very comprehensive horizontal legal framework. So this make this type of harm unlikely to be addressed by either privacy-related regulations and other regulations that can make them more easily to escape legislative and regulatory attention. And I think in many cases, because they are very opaque, intangible, and discernible, legislator may not think that they are super serious and not a very immediate problem that they should really just have to take more proactive action to really address those issues.
Great, and nice question, Charlotte. And I definitely think if you haven't put that in the paper already, it's a great question to answer like you did in the paper. Other questions? Houchin.
For Ed, I really enjoy your presentation. So I wonder whether you could share your thoughts about the implication of SCHUFA's ruling for dealing with targeted advertising in Europe, because I think Europe courts in Europe have been grappling with whether, for example, Facebook's targeted advertising should be allowed or banned in Europe in the targeted advertising dealing with a collection of social media platform users' preferences, personal information, etc., etc. In most cases, such collection is made without users' consent, prior consent. So I wonder how you think about the implication for targeted advertising.
Thank you, Houchin, for this question. I guess if we are talking about targeted advertising and whether Article 22 will apply to this situation, there are several questions we need to prod further, like whether targeted advertising is based on this solely automated decision making, whether it is a type of decision making that is making an effect or having a legal consequence or similarly significant consequence on an individual when we send advertisement to an individual. So I guess some cases of advertisement that we get are maybe innocuous, but some types of advertisement may be very different, like this famous example by Professor Latanya Sweeney about she being a Black professor at Harvard. She got very curious how come she kept getting advertisement of seeking legal advice. So in the end, she found that it was based on this racially biased algorithm that they targeted based on your name, based on your family name. They targeted that it was likely to be Blacks, and that likely the Blacks will get into trouble with the police, and that's why they get advertisement of legal advice or legal counsel. So that type of advertisement probably will have this adverse legal consequence on an individual and likely to be fall within Article 22. But for other type of advertisement, then I'm not exactly sure that whether it will fall within Article 22 in that sense.
I want to come back to Xiaowei for a second. I loved your example of the New York Times page, which asks for you to click or to provide your email address. But first, I want to ask the audience, when you are asked your email address, do you give it your real email address? Or how many people give it? I'm just like, as a matter of course, for something where you just want to read one article, how many of you give it your fake email address? Just curious. So it's really, yeah, I'm actually really shocked that within this group that it's that few people, right? There's no, the New York Times doesn't know whether or not you're actually, maybe you have to, all it requires is a second Gmail address or a second Hotmail or whatever service you want, right? So I'm actually really stunned that people give it the errant website that asks their real email address. Okay, so what about the people like me, like very few of us who are giving it their fake email address? Is that consent in any way? I mean, I do it grudgingly. It's like, here you go, here's my crappy email address that I'll never open. And you can spam it as much as you want.
I think that's an agreement.
That's-
Like you can just give fake email. Yeah.
Okay.
As long as you can verify your email.
Yeah.
And confirm.
Yeah, okay, that's a good answer. I buy it. All right, other questions? Ron,
Xiaowei, I just had a quick question for you. Given that a lot of terms and conditions have a time-sensitive clause, i.e. that the terms and conditions can change at any moment, how do you deal with that in your research?
So we think that is definitely a pseudo contract because it's never communicated fully to consumers, especially there are empirical studies show that some health app, they promise that they will protect your data, but then after you give them consent, they will immediately change the policy and without notifying you. So based upon our framework, we think that's definitely a pseudo contract. It's never fully communicated with consumers.
great. I'll take one last question. Yeah, Charlotte.
So this question is for Michael. You mentioned a judicial sui generis approach. What do you think of a regulatory sui generis approach for generative AI? I mention this because I think that you're right in that many data protection principles that we've been dealing with for quite some time are very applicable. But there are certain types of things like the right of erasure that are nearly impossible to effectuate, at least in a very complete way, with both generative AI and other types of AI. And so I'm curious what sort of the regulatory intervention is here, if anything.
Can I just add to that question? It seems to me that the GDPR has become sacrosanct. It's become above every other norm in some sense. You cannot erode any of the GDPR requirements. So you see with other bills, the kind of statement that these do not undermine any of your rights under the GDPR. So would this require something that manages those rights in a particular way?
Not necessarily, because there's a difference between an unrelated non-data protection bill, which is not based on the data protection basis in the treaties. So it's not a data protection law saying that this doesn't affect data protection, and what's called lex specialis, a specification of the data protection law. So the key is in the word G, general data protection regulation, just like there's a general product safety directive. And within that, that's a baseline. It's perfectly possible to make sector-based data protection rules. Perfectly possible to go and say, in this case, we have actually got a specialized idea of what this looks like. So the e-privacy directive is often considered lex specialis to the GDPR for certain areas of information placed on and off devices. It's not exactly an elaborate regime in that regard, but that's the sort of place and it's what's considered in the interaction. So we were going to say, and I'm very supportive of lex specialis for, say, text and image data in the GDPR. So to have a separate regime, because as I said with emails, I don't think that the GDPR, because of its heritage in older data protection law, has really got the conceptual tools to deal with high dimensional data like text and images, just because they aren't queryable in the same way. Even language models actually make them more queryable, but still I think it might need some refinement. And of course, they're very expressive, which maybe creates other trade-offs that need to be elaborated and would create clarity. Similarly, I would be supportive of considering, maybe not AI in particular, but thinking about code or software perhaps, and thinking about other forms of data. You might have sort of how you would operationalize certain rights in other kinds of regimes. And I think you could be quite creative there. That's similar to what we've seen in the proposed, maybe it'll pass, the Platform Work Directive. That is also lex specialis to the GDPR if it passes. The Platform Work Directive has all the sections on algorithmic management, which are based on TFEU 16, so the data protection legal basis. and they would be specializing and specifying the automated decision principles of the GDPR to go further in the area of platform work. So I think it's totally possible to do that. Now, that's not eroding. What that's doing is saying, let's look at the charter, let's look at the fundamental rights data protection, what that's meant to do. At the moment, these are not being sufficiently protected because they're not sufficiently specialized. We don't know how to interpret them. They're not specified enough. And so therefore it's a specification rather than an erosion. I think that would be key to do. Now, one last thing, member states can also derogate from the GDPR so that they can place in, say, in my country, it is considered to be the task in the public interest to train generative models and to use them in that way. And they could make a part of their national law, which gives a separate legal basis for, say, running a generative model for a certain set of purposes. So making a new legal basis within one of the existing ones, sort of giving it is totally possible to do. And that can be done as well. So can restricting certain rights like erasure, that can also be done at national level.
But let me just press that. Let's say France says this is how we interpret this basis. But how does that, how would that model then survive scrutiny by someone in, say, Austria, who might not, where, let's say the LLM provider would not have the same interpretation available?
Yeah, so you might then want to make that at union level, which is possible. So, for example, the final draft of the Act, whether it is a final draft, is not out, but in earlier versions, the AI Act made a new ground to process data, or rather, it said you can treat this. I think it was as a legal, not as a legal obligation, a task in the public interest, could be debiasing a model. So you can process special category data for the purpose of debiasing an AI model that's high risk. And that was a union level provision. So if you're right, it would create fragmentation if lots of member states did one bit to another, but it's perfectly possible for a piece of union law to say, union law says this is allowable, and therefore you can process data in this way. So there's lots of options without, so I think some people are ready to like rip up the GDPR, but the GDPR has extensive ways to tailor and customize it. The rights can be restricted very heavily in many areas. Just look at the UK Data Protection Act. The schedules that restrict the rights that data subjects have, they go on for like 100 pages. It's saying, erasure doesn't apply in this situation. If you have an exam, you can't have a right of access until 140 days after the exam has been finished or the exam results have been published, all these kind of things. Like all of this stuff is specified, and it's totally possible just to specify within the context and say, erasure doesn't apply for models unless these circumstances apply. The CJ would still have to go and say, not for the UK, but for other countries, say, is that fair? Is that a balancing act? Is that actually a restriction that would breach the Charter right of data protection, that restriction? But if it's a reasonable restriction, it's going to pass that test.
Well, please join me in thanking our wonderful panelists.